right into People Against Ryan as we continue our consideration of mens rea. And this case should recall for you one of the hypos we discussed between earlier cases, because it involves that whole mushroom thing, okay? And now we see the real case that hypo in the book was based on. So someone tell me how Ryan got himself into trouble.
He was speaking with a friend, wanted to order some mushrooms.
Well, let's say a friend.
Yeah.
A friend in quotes.
Yeah.
And his friend was Hopkins.
Yes, sir.
And what happened between him and Hopkins?
So Hopkins called, I guess, whoever his friend is that has all the mushrooms. And then an agent was tipped off, it says, or tipped off to the transaction, an investigator.
Now, wait. We gotta back up.
Okay,
We
yeah.
gotta back up. I need more. Actually, it was Ryan who called Hopkins.
Okay.
Right? Called Hopkins.
Yes, sir.
And what did he ask Hopkins to do for him?
Receive a shipment of mushrooms on his behalf.
On his behalf, right? It was Ryan who asked Hopkins for this favor. And what did Hopkins say? Because you said he's a friend. What does a friend do if you ask for a favor?
Of course, yeah, I could do.
Sure, anything for you, pal. So Ryan said he called Scott, asked for the usual shipment.
Yes, sir.
The usual shipment. So, and as you say, an undercover officer
Was tipped off.
gets tipped off to all of this and gets the package.
Yeah. So,
And delivers it to Hopkins. And what happens to Hopkins?
so then Hopkins says, "Oh, well,
Well, first what happens to him?
Okay.
Because it's delivered to him not by some innocent delivery person, but by a
the
policeman.
agent. Yes, sir.
So
yes,
what
sir.
do you think happens to Hopkins?
He gets arrested.
He gets arrested,
Yeah.
right? He signs, he accepts the package, and he is immediately arrested. Now, let's imagine you're Hopkins.
I don't want to be in his spot. No, I'm playing.
Okay, you don't want to be in his spot, but what did we say about Hopkins and Ryan?
They're friends?
They're friends. So if you're Hopkins and you just got arrested, what's the last thing you're gonna do as a friend?
Tell him my friend?
You're gonna what?
Tell him my friend?
Right, you're not gonna sell out Ryan, right? Because friends to the end. Right?
Yeah.
If you have to go down, if you have to take the fall for these mushrooms, you're gonna take the fall, right? And Ryan, you're not gonna name Ryan. Ryan's gonna be left out of it because he's your
Friend.
friend. You'd almost think the way I'm stressing this, like friend might be the word of the day,
Oh, man.
but it's not. Okay? So that's what Hopkins does. Hopkins takes the fall.
Yes, sir.
Does he?
Oh, I thought he set up the
He
other guy.
didn't take the fall
No,
at all.
yeah.
He sets up Ryan. He's like, not my mushrooms. I was just doing this for a
Friend.
friend.
Yes, sir.
Okay? So he sells out Ryan and says, does bat an eyelash. He says the package is Ryan's and I will participate with you in a surprise look because Ryan's expecting a call from Hopkins. So he's going to get a call from Hopkins, and what's going to happen?
He's going to get arrested.
He's going to get arrested. He calls Ryan. He says, we have a shitload of mushrooms.
Yeah.
Just waiting for you. And he says, 2 pounds. And Ryan says, don't say anything, because Ryan's no dummy. Okay? And at the meeting, Hopkins gives to Ryan
The package of mushrooms?
the package of mushrooms,
Oh no, a fake package.
a
yeah.
fake package.
Yeah.
And as a result, Ryan is arrested. And what is he charged with?
Charged with possession, knowingly and unlawful
What's he
possession.
charged with?
Let me see.
Attempted possession. Why attempted possession?
Because he didn't actually have the mushrooms.
Because it was a fake package.
Yeah.
The fake package. We will do attempt later on in the semester, but here's our first little glimpse at it, right? A lot of times when you get these cases where undercover officers set people up, here we had it as a result of, the intervention with Hopkins. But when it's a setup and they're not getting real cocaine or real mushrooms or whatever it is, attempt is the charge, because they're not really actually in possession of, with whatever intent they may have, whatever intent may be required. So it's attempted possession here of a controlled substance. So at trial, the prosecution introduces certain evidence that's relevant to our consideration here. What evidence does the prosecution introduce?
One second. Oh, about the weight of
About the weight.
And
This
then
ended up all being about the weight, sort of this package and the mushrooms and the
percentage
hallucinogen.
of, yeah.
So what evidence do they try to introduce?
So they said it was close. Like the package was 932.8 grams, about 2 pounds.
Not 2 pounds. So the one is package contains about 2 pounds
Of mushrooms.
of mushrooms.
And that 140-gram sample of the package contained enough to break the statute. So 796 milligrams of the
796, you said?
yes, sir, milligrams mgs of the hallucinogen psilocybin.
Psilocybin.
See, you got
Spelled that right? Probably not. Psilocybin. Let's see. Okay, so of psilocybin, and that why does the prosecution care about this proving that the package had 800 milligrams or easily over, in fact, 800 milligrams once you take, because this is only a sample of the 2 pounds.
Because of statute and penal law, section 220 says making it a felony to knowingly and unlawfully possess 625 milligrams of a.
Felony to knowingly, there's our mens rea, right?
Yes, sir.
Knowingly and unlawfully.
Possess.
You don't want, if somebody has some psilocybin as part of a study, let's say they're a researcher and they have it lawfully, they would obviously knowingly possess this stuff, but that's not a felony. So the unlawfully is in there to provide for that. Knowingly and unlawfully possess what?
625 milligrams of a hallucinogen.
Okay. So the prosecution here says, look, there were 2 pounds in this. A tiny fraction of that goes over
Yeah.
625, so we're good, is their argument. Okay? And that's why they want to introduce all this evidence. Okay? So what argument did Ryan make at trial?
I think he said basically to throw it out because he didn't really know. So let me see what he says. Moved to dismiss for insufficient proof that he knew the level of psilocybin in the mushrooms.
Ryan, I did not know, or the prosecution didn't introduce any evidence that I know, the level of the hallucinogen in the mushrooms. This lack of evidence that I knew means indictment should be dismissed. What does the trial court, and for that matter, the intermediate appellate court, what did those 2 courts say about this argument?
They held the defendant must know the nature of the substance possessed and acknowledge that the weight of the substance is an element of the crime.
Is what?
Is an element of the crime?
That's what the
Appellate court said.
lower courts held?
That's what. Oh no. Yeah, I think that's what the appellate division held, but I know the lower
What
court.
did the 2 lower courts hold? Give me it again, because I may have misunderstood what you were saying.
The court held that a defendant must know the nature of the substance
The
possessed
nature of the substance, that is, that it's a hallucinogen, good.
and acknowledge that the weight of the controlled substance is an element of the crime.
That's not what the lower
That's not
court
it?
held.
This would have knowingly referred to the possession and not to the weight itself.
So the lower courts, knowingly is an element of the crime, of course, we see it right there, can't deny that, refers only to what?
To the possession and not to the weight itself.
Oh.
So they say, get out of here with that argument, Ryan. Motion denied, and denial affirmed, says the lower appellate court, because knowingly means you only have to knowingly possess, right? And he did knowingly at least attempt to possess, and that's why it's an attempt crime. He attempted to knowingly possess the hallucinogen. So the lower court say, it doesn't matter whether he knew that this amount of mushrooms had 1 milligram or 10,000 milligrams, because the knowingly element does not refer to the weight. That's what the lower court told me. Okay, somebody knew, somebody tell me, what does the New York Court of Appeals say about this?
Knowingly should refer to every element of the offense.
Knowingly should refer to, and how did they reach that? It should refer to every element, including the weight. And how does the Court of Appeals go about reaching that conclusion?
Because if not, it would be strict liability.
I'm sorry?
If not, then the statute wouldn't have its meaning, and they said something about it would impose strict liability.
Before we get to that, the court does say that, and I do want to talk about that. The court starts with something a little simpler, maybe.
It says unless the legislature clearly intended for the knowingly part to apply to some elements of the offense, but not others, then we're going to presume that the intent does apply to all elements of the offense.
The court says, let's first look at the plain language of the statute. The plain language of the statute and what the legislature intended, right? It specifically says the defendant must have knowingly and unlawfully possessed, or in this case attempted to possess, 625 milligrams of a hallucinogen. The court says that if you say this, that does not apply, the knowingly does not apply to 625 milligrams, you're basically reading that out of the statute, at least in terms of mens rea. At least in terms of mens rea, okay? And so the court is not going to eliminate the weight requirement because it would rob the statute of meaning, okay? There is a mens rea associated with the weight of the drug, okay? So I want to pause here. To note this principle, because it's really pretty important and it's reflected in the Model Penal Code, that the mens rea should apply to each element of the offense. Okay? That mens rea should apply to each element of the offense. Let's look at purposely under section 2.02, A1 and A2 of the Model Penal Code. Back of your book. 2.022, A1 and A2. So that's on page 1133 of your book. Okay? I want you to think for a minute, give you a second to think about this. What's the distinction between A1 and A2?
It looks similar to the difference between
purposefully and knowingly, doing something purposefully and doing something knowingly.
Well, they're both definitions of purposeful, but they relate to different elements or different kinds of elements of offenses. Right? They're both the way the model penal code tries to characterize purpose, but we're not going to use a blanket rule that purpose means different things as applied to different kinds of elements. A1 is one kind of element, A2 is a different kind of element. What's the difference?
Is one intentional and one is attempted?
No, not really.
It's one because of his circumstances and the other.
I'm sorry?
One's because of something, his actions, and the other one's the circumstances.
What do you mean his actions? Which one are you talking about?
The nature of his conduct.
The nature of his conduct. So if the element relates, as A1 describes it, to the nature of the defendant's conduct or the result of the defendant's conduct. So that's one kind of element, right? That might be something like the result of your conduct could be you killed somebody. That's the result of the conduct, or what you did. If it's that kind of element, then the jury should be told that, and purpose should be about whether the defendant had a conscious object to engage in that conduct, that is, it was her purpose, or that the conscious object was to cause that result. And that makes sense. If it's that kind of element, then purpose should mean that it was your conscious object to either do that thing or cause that result. But A2 directs us to a very different kind of element. It's not about, well, what did I do or what did I cause, but it's Mr. Kuhn.
Yep.
Mr. Kuhn, what kind of element are we talking about with
Intended
A2?
circumstances.
I'm sorry?
Intended
The circumstances under which you did it, right? Like, these are the circumstances. The circumstances where it was a hallucinogen, right? Or in burglary, that, for example, in burglary, usually it has to mean, at least for some parts, some definitions of burglary are that you have to enter a dwelling or that it has to be at night. Those are the circumstances. Right? And when that is the kind of element we're talking about, how does the Model Penal Code in 2.022A2 say we should understand and apply purpose as a mens rea?
Is that because he is aware of his existence of circumstances, or he believes or hopes they exist?
Or believes or hopes that they exist. Okay? And one of the reasons that seems like a softer or lower threshold for purpose is that the drafters of the Model Penal Code thought, well, we shouldn't hold the prosecution to be able to show that kind of the defendant, since the defendant doesn't usually create the attendant circumstances that surround their offense, that they shouldn't be required to the prosecution have to show, oh, the defendant intended those circumstances to exist, right? So the key takeaway here is you can't use just one blanket approach. You have to look at each element specifically, assess what kind of showing has to be made beyond a reasonable doubt to satisfy that element combined with that mens rea. Makes it that much more complicated.
I was about to ask, so in this particular case, in the Ryan case, what would be the attendant circumstances in question exactly? Would it be the weight of what they attempted to pass off, or would it be that it was a setup in general?
Possession would be the
Okay.
conduct of the defendant.
Okay.
The weight and the hallucinogenic characteristic of what Ryan attempted to possess would be attendant circumstances.
Okay.
Okay? Okay. So, we have a plain language approach that the court uses that, hey, 625 milligrams is in there, it relates to knowingly, that's one answer. The court also uses two rules of construction. What are those? Ms. Limewater, let's go back to you.
Line weaver?
I'm sorry?
Line weaver?
Oh, Line Weaver.
Yeah, it's a correct water. I did that
You guys, your handwriting. Killing me. Weaver, got it. Okay. Ms. Lineweaver, what sort of rules of construction does the court try to use? And you sort of were going there originally.
Oh, it's a strict liability.
What does the court say about strict liability?
If you make it so they only have to know one element, then you're holding them accountable for the whole offense, even if for just one thing, you're just holding them accountable in this way. Is that right?
If strict liability, even for one element. The court says there is a presumption against that. Under New York law, if any material element lacks a mens rea requirement, is a strict liability crime. Okay, and so that's a problem, right? We don't like that. And what else does the court say? What makes one other really interesting argument that I want to call attention to? Harper?
They say that the prosecution's argument that it would be too difficult to prove that the defendant knew anything about the weight would be.
Well, I want to talk about that too, but let me get to that in a minute, so I'm going to come back to you with that. That's the prosecution's whining argument. For us, we can't prove the crime if you hold us to this standard. But before that, the court makes another argument. Ms. Mwaga?
It applies to all elements unless a contrary legislative intent is.
That's kind of this.
Where they say that you don't want to ascribe to the legislature this idea that they would mete out drastically different punishments without a basis in culpability.
Different punishments. Expand on that. Tell me about the structure of this law.
The law has different grades of, I guess, the offense, and so you're punished differently based on which grade of the offense you are at.
And that grade is based on how does the crime
In this
get ever
sense-
more serious?
Yeah, in this instance, it's based on, I guess more weight is more serious, and so you get into felony or misdemeanor territory
The
depending.
court says, look, the structure of the possession law imposes different punishments for different levels of weight. How much you were attempting to or actually did possess. And the court says, look, if under the structure of this law, the legislature was imposing more serious, greater culpability based on this factor, that we will not ascribe to the legislature an intent to mete out drastic differences in punishment, this is on 248, without a basis in culpability. That would be inconsistent with the notions of individual responsibility and proportionality. This is the court's way of using the purposes of punishment, right? To say, look, the purposes of punishment are to, as we talked about, make more serious crimes punished to a greater degree, and we're going to let that control our interpretation. So the structure of the law will be interpreted to include mens rea for this element. Now, Ms. Harper, you said that the prosecution has a counter argument to all of these interpretive approaches that the court uses. And what was that again?
Well, in the prosecution's words, it would be prohibitively difficult for them to secure convictions if they were required to prove that the defendant had knowledge of the weight.
And if you were the attorney for Ryan, and the prosecution came in arguing, look, don't interpret the statute this way because it would be just too hard for us to win, what would your answer be?
Outside the courtroom, I would probably be laughing my head off because
Well, that's not going to help you very
I know,
much.
but inside the courtroom, I would point out that they must not know how these sorts of deals usually go down because there's usually a lot of negotiation regarding weight and pricing. That's how these sorts of drug deals
But if
work.
it's about knowledge of the defendant's weight, the court sort of says there will often be evidence based on negotiations, based on if you can show the defendant's experience, if you have wiretaps, maybe you can show the defendant, you can get the defendant to say from the defendant's point of view, wrong thing. Okay, but is there that all of that might be reasons why the prosecution's argument is factually wrong, that in fact it won't be that hard to convict, that there will, but the Court of Appeals also acknowledges there will be circumstances in which this requirement will prevent conviction, because what we may think we know from the defendant's conduct, what may be sort of common sense would tell you is not the same as having proof of something. What's the more fundamental answer to that argument? What's the fundamental answer to the argument that the prosecutors are making? I'm sorry?
Never mind, I'll play the rest of your
Yeah.
That with a pure substance like psilocybin, it's hard to determine the weight because you're cutting it with something else, or like putting it with nothing.
That sounds like that sounds like a pretty technical argument. I want something more fundamental here. If I would say one sentence to the court in response to that argument. What one sentence do you think I would say?
There was no evidence that Ryan knowingly intended to possess the amount.
Yeah, but that's the prosecution saying, but you shouldn't require that there be evidence of Ryan's knowledge, because otherwise we can't convict him or people like him.
The burden of proof should be on the prosecution.
And yeah, that's going in the right direction.
The purpose of the knowledge requirement from the get-go is to keep people from getting over their laws. If they didn't know they possessed that knowledge.
Getting there. I like the answers.
Up to the jury to decide if they prove.
It's not up to the. It's not. I don't want you to be focusing on the jury right now. Who should you tell the judges on the Court of Appeals that the focus should be on with this argument? The legislature. Good. Tell it to the legislature. That's what I would say. If you think that this requirement imposes too great a burden on law enforcement, Mr. or Ms. Prosecutor, and it will make it too hard to punish those who should be held culpable, then tell the legislature to change the law, right? The legislature wrote this law requiring that there be knowing possession of this amount. And if that causes problems, it's not for the court to bail out prosecutors, simply because prosecutors, I'll use the word again, whine that the law makes it too hard for them to convict people. Courts don't amend laws, they interpret and apply them. Legislatures do so. Legislatures amend them if they cause problems one way or the other, if they're too draconian, or if they're too liberal and let people off who the legislature we decide through our representatives ought to be convicted. And on that score, what happened to this law after this decision?
They rewrote it.
The New York legislature said, we agree with the prosecution. We agree, if you look on note 3 on page 250, that it should be possible to convict with knowingly modifying only possession. If you knowingly and unlawfully possess a hallucinogen, and said hallucinogen weighs 625 milligrams or more, right? So the prosecution's argument did get an answer. In fact, the answer the prosecution wanted, but from a very different forum. And it's the forum I would suggest to you is the right place for this argument, not to try to affirm a prosecution that was not appropriate under the statute as it existed when Ryan was prosecuted. Okay? Questions? All right, I want to talk about default rules. If you look on page 251, Model Penal Code has a default rule for culpability, that is for mens rea, when none appears in the law. What's the default rule? for what the prosecution has to prove. Ms. Allen?
Recklessness?
Recklessness, right? Section 2.023 says recklessness because that's the lowest one mentioned in 2.023. So if the prosecution can show the defendant acted purposefully, knowingly, or recklessly, it wins. Recklessly, in other words, is the lowest one, so it suffices under this default rule. Negligence does not, right? So not only does the model penal code disfavor strict liability, it disfavors negligence because the model penal code drafters believe, if you look on 252, that negligence is an exceptional basis of liability and it should be excluded unless the legislature specifically says negligence is the basis for culpability. So if the legislature wants to impose anything, either strict liability or negligence, it has to be very clear about that, explicit in the statute. It can't use silence and have the court infer, at least under the model penal code, infer that is the applicable mens rea. Right? So if I told you it's a model penal code state, and I gave you a statute in which the mens rea was silent, you should default to recklessness. The prosecution would have to introduce sufficient evidence beyond a reasonable doubt that the defendant acted recklessly. How many of you think you got that rule? Now, do you understand that rule? Not seeing any hands. Okay, let's make sure we got that because I hate to tell you the Kentucky rule is 10 times more murky. So somebody try to state back to me the model penal code rule.
Okay, I don't know if this is right. So basically, if the statute is silent on mens rea, then the default is recklessness.
The one the court should read in,
The one that should read it.
because the model penal code certainly hates strict liability.
Yeah.
And what this is telling you is it doesn't like negligence much either,
Okay.
right? So it's, if the prosecution has sufficient evidence to prove beyond a reasonable doubt that the defendant acted recklessly, and certainly any one of the higher mens reas, right? Because those, if they can show purposefully or knowingly, then they meet and exceed the requirements for recklessness. So if the prosecution has evidence of recklessness or higher on our hierarchy, then the prosecution can win. And the model penal code calls on courts to apply recklessness as the minimal one that will suffice, that the prosecution will be held to in the case of a statute where the legislature just left it out.
Okay, can I ask a question then?
Mhm.
How do we know, looking at a statute, if it's intended to be strict liability or if you're supposed to read that?
That's what the model penal code is telling you. Under the model penal code, they are telling you that if the legislature left it silent, your next step is to impose recklessness.
So
That if the legislature intends to impose strict liability, it must say so.
Okay, that's what I was.
It must say so. Or if it intends to apply negligence, it must say so. Right? And if it is silent, we will default to, that's why we call it a default rule, we will default to recklessness. For what that means for the prosecution, I mean, it doesn't have to own, it doesn't have to act, it's not limited to recklessness, but it has to show at least recklessness. It has to show recklessness or knowing or purposeful. But at least recklessness.
Never mind, I think you answered my question.
Okay, and how do people feel now about the model penal code? Everyone got it?
Mm-hmm.
Yeah, but
Question?
So is the default the takeaway from this case?
No, this is we're now moving beyond Ryan. Because here we don't have to worry about a default rule because there is one in the statute. The default rule is for situations in which the statute is silent. In Ryan, the New York Penal Code had knowingly, so we know it's knowingly. Now the question is just what does knowingly apply to? We moved on to a whole different question. It's not about Ryan.
So for example, if the statute said felony to unlawfully possess, okay.
Right. If the statute didn't say knowingly, just said no one unlawfully possesses 625 milligrams of a hallucinogen. The model penal codes answer to that was, what are you supposed to do? Are we supposed to use just strict liability because it's silent? The Model Penal Code's answer was no. The default in the case of silence is recklessness. That's the minimal one, right? If prosecution can show knowingly or purposely, great, but they have to at least be able to show recklessness, okay, if the statute is silent.
Couple of questions, I guess. If you, let's say that statute says knowingly and unlawfully possessing something.
Right.
If the prosecution brings evidence to suggest recklessness, is that not good?
That is not good enough.
Okay.
Remember, it works in a hierarchy.
Right.
If the statute says one of the levels, and the prosecution can go above that level, that is, in the case it says knowingly, but they can show purpose, then that suffices. But if it's lower, that does not suffice. So if the statute says knowingly, and they can only show recklessness, that does not suffice.
Now, what if, so if they did show knowingly, would that imply any of the lower hierarchy?
It would satisfy any of the lower. I don't know if it would imply it, because I would think, I haven't thought about this, but my knee-jerk answer is that if you knowingly or purposely do something, you're not reckless, right? I mean, but it doesn't matter, because whether it implies it or not, it satisfies. Prosecution wins.
Okay, sorry. So when I look back at when we did Dillard, for example, it wasn't written, the knowledge component wasn't written into the statute, but then they interpreted it that
Right.
way. So how do you know, did it?
Because the answer is, I don't mean to interrupt, but the answer is, I'm telling you what the Model Penal Code approach is, right?
Okay.
There are other approaches,
Okay.
like when we did Dillard, that courts use that differentiate, not based on this strict rule about a default rule, but is it a public welfare offense? Is it a traditional common law offense? How serious is the crime? The Model Penal Code doesn't care how serious the crime is. They do not want strict liability.
So it just
Okay.
depends on what.
As I have promised you, I will tell you what law
Okay.
applies. Okay? All right. Now, Kentucky just couldn't, to the extent that that was simple, and I'm not saying it was, but to the extent that it was, Kentucky decided, let's make it even more confusing, what the default rule should be in the case of silence. KRS 501.040 says that a mens rea should be found in a statute which lacks a culpable mental state. That is in the case of silence. If the prescribed conduct necessarily involves such culpable mental state. So if you can't, in other words, if you can't have the conduct without the mental state, then read it in. If you can't, so if the conduct couldn't have occurred without it, then you should read it in. So there's no one default rule. It goes offense by offense, and in some cases even case by case. So let me give you two examples just to show how unfortunate the Kentucky rule is. A case called Covington against Commonwealth, and if you're interested in looking it up, the citation is 849 Southwest 2nd 560. 849 Southwest 2nd 560, and it was from the Kentucky Court of Appeals in 1993. Okay? And in that situation, the Court of Appeals upheld a conviction of an inmate for third-degree assault. Because it held that the injury that he inflicted on a prison guard, he had actually attacked another inmate at Eddyville. And when guards intervened, he struck one of them twice. Said that conduct, third-degree assault, necessarily couldn't occur without either wantonness or intent. So we're going to read in those mens rea and upheld the conviction. Okay? Later, however, 2001, in Love against Commonwealth, and that was 55 Southwest 3rd, 816, Kentucky Supreme Court 2001, 55 Southwest 2nd, 816. And again, when I give you these cases, you don't need to look them up. You don't need to go read them. You're not responsible for them. I just give you the citations in case you want to. You're only responsible for what I tell you here in class about these cases. In Love, a guy was driving drunk and ran into an accident scene that had been caused by a previous drunk driver. I kid you not. Okay? And he killed several first responders and wounded others driving drunk through this accident scene. I mean, it's just awful. The Supreme Court held that a conviction for third-degree assault had to be reversed because it depended on knowledge that the individuals whom the defendant had wantonly endangered were police officers. The statute involved there, I should tell you, makes it a felony if a person recklessly, with a deadly weapon or a dangerous instrument, or intentionally causes or attempts to cause physical injury to a state, county, city, or federal peace officer. Right, so there are mens rea elements there as to, wantonly endangering, recklessly using a dangerous instrument, but it doesn't have any mens rea with respect to the status of the people you wounded being a state, county, city, or federal peace officer. Okay? So the court said, and I'll just quote here, appellant tendered third-degree assault instructions that would have required the jury to find him guilty of that offense if he recklessly caused injury to the officers while they were acting in the course of their official duties, and if he knew they were so acting at the time of their offense. Instead, the jury was instructed to find appellant guilty of third-degree assault if he recklessly caused injury to the officers while they were acting in the line of duty, regardless of whether he knew it. Regardless of whether he knew it. Okay? So the instructions did not require a culpable mental state with respect to the status of the victims and imposed absolute liability as to that element of the offense. And this violated, the court said, 501.030.2, which requires culpability with respect to each element of the offense, and 501.040, because Love could not be convicted of assaulting a police officer absent knowledge on his part that his victim was a police officer. Now, I asked you if you were clear on the model penal code. How many of you are clear on what Kentucky would do? Which means you got it. I mean, I'm just going to tell you, the Kentucky rule doesn't just invite confusion in its application, it's inevitable, right? I mean, the takeaway is that what you have to do is look at the specific circumstances, the specific offense here that the person was a peace officer. And it seems to me, if I was deciding this case, that my answer would be, look, the statute simply says that they were a peace officer. You can cause harm. You can act in a reckless way, and the harm you cause is to a police officer. And you can do that. You can fulfill that offense without a mens rea element as to the fact that it was a peace officer. So if the real requirement of 501.040 is that the crime be possible to be committed without a mens rea, that's satisfied, but the court held otherwise. So I can't really tell you what 501.040 means in operation. I can just tell you that that is the default rule.
What's the citation after 816 for law versus Commonwealth?
816, it's just Kentucky 2001. 816 is the page. So it's 55 Southwest 3rd, 816. And it's the Kentucky Supreme Court 2001. Okay? So let's try to explore this a little more in a different context under federal law and the Alonis case. The Alonis, everyone thought when Alonis Alonis came before the Supreme Court a couple of years ago that it was going to be a big First Amendment case. Because Alonis was alleging, and the case went to the Supreme Court, presenting the issue, did conviction under these circumstances violate his First Amendment rights? And a lot of what happens in the court's decision was its effort to duck the First Amendment question, to duck it completely, and say, well, we'll just say that he can't be convicted under these circumstances by interpreting the statute, rather than holding that it either would or wouldn't violate the First Amendment. So, what is Alonis charged with? Ms. Ramaswamy, right?
He's charged with making threats to injure his ex-wife, police officers, in a kindergarten class.
Kindergarten, you say?
What?
Beyond the law.
That's
Kindergarten. And where did he make these threats?
on Facebook.
On his Facebook. And the takeaway from this, or one of the takeaways from this, is be careful what you say on social media, because bad things can happen. And what was the first thing that his wife did upon seeing these repeated, at least in her mind, threats?
She brought a state court to grant her a 3-year protection from abuse order against him.
And what would that, if you were the prosecution in this case, how would you use the fact that she went to state court to get protective order?
That she took these threats very seriously.
Exactly, right? One of the things you're going to try to show, and one of the disputes in this case is whether it's enough, but one of the things you're going to want to show is that these threats, in fact, were taken seriously, were seen as a threat, that these statements were, and then you'll try to show that his wife was reasonable, so that a reasonable person would have seen them as a threat. And what else does the prosecution try to introduce to make the case that these were threatening statements?
They also have witnesses, so they have your wife testify, and also coworkers
That,
said that they felt afraid that
right. And all of this is built on the premise that from the prosecution side, that if they can show that these were taken by the readers, taken by the objects of the statements, that they will suffice in showing that the comments were actually threats, and that it satisfies whatever, and we'll talk about it, whatever mens rea might be required under this statute. Okay? So that's the prosecution's case in a nutshell. And tell me a little bit about the statements, because those are also going to be part of the evidence the prosecution introduces.
Well, it began with him posting like rap, self-styled rap, with violent language and imagery, and he claimed that these weren't, or he would put disclaimers within them though, saying that these were fictitious and not actually supposed to be about specific people. And then he posted a video like that imitated a comedian sketch saying it's illegal to say, and replaced, and it was talking about how it's illegal to say you're going to kill the president, and then he replaced the president with his wife.
But he was, he talked about how it's illegal to say you're going to kill the president, but it's not illegal to say it's illegal. So he put that on there. What did he say about a protective order?
Should we actually say it? He was just saying, like, do you think if you put it in your pocket, is it thick enough to stop a bullet?
Now,
Oh my God.
if you read that on Facebook from somebody that you had just obtained a protective order against, what would your reaction be?
I'd be very scared.
Be very scared, right? And maybe others wouldn't be. Right? Maybe others would, based on the context, based on knowing the person, might think this is just bluster, or this is his or her sixth sense of humor. But certainly, if some people were scared and found that to be threatening, we wouldn't be shocked at the very least. Certainly wouldn't be shocked. And what this kindergarten class, how do we get a kindergarten class into all of this?
So then later that month, he posted another entry, and then he said he's gonna, like, along the lines of making a name for himself, and that he's like close to elementary schools in a 10-mile radius to initiate the most heinous school shooting ever imagined. El Path, no Fury, like a crazy man in a kindergarten class.
Okay. So and all of this is brought to the attention apparently of federal authorities. And and under what statute do they charge Alonis?
U.S. Code Statute 875.
18 U.S. Code, Section 1875. C, right?
Yeah.
And what does that say?
It makes it illegal to, I think, to threaten people, not within, I don't know the specific, along the lines of you cannot, illegal to transmit threats and.
What? Any communication containing any threat to injure the person of another. Okay. What was the jury? Let me ask you first. Anything in here give you a mens rea? Just transmit it.
Yes.
Now, it has to be a threat, and that's where a lot of the dispute comes in. Since there's nothing in there, what did the trial judge tell the jury it had to find?
They just had to prove that he intended to communicate a threat.
Really?
A true threat.
What was the jury told?
They were told to find that a reasonable person would perceive a statement as being interpreted as a threat.
He communicated, not that he intended it to be a threat, but that a reasonable person would have perceived it as a threat. Since it has to be a threat, and you can see how this makes a huge difference in a case where we're trying to ask ourselves, what is the prosecution's burden? What do they have to show beyond a reasonable doubt? If they have to show that he knew that it was a threat or intended that it be a threat, right? That's much harder to prove, or certainly different to prove, than simply that a reasonable person would have regarded it as a threat. And though the prosecution's proof was all aimed at this idea of, look how these people responded, look how these people thought of this communication, okay? And what happens to Alonis?
He gets convicted.
He gets convicted, okay? Now, this is the equivalent in terms of defining what constitutes a threat of what model penal code standard. When we ask a reasonable person standard, we also have a difference in terms of from whose perspective. But if we're asking about a reasonable person, what model penal code standard is that?
Knowingly?
No.
Negligence?
It's negligence, right? Negligence asks, was your conduct reasonable? Now, recklessness is you were aware of the risk and took it anyway. Negligence is, Well, maybe you weren't aware of the risk, but a reasonable person would have been. What a reasonable person would have been if you used your common sense. Okay? So this is certainly not the model penal code's default rule, because the model penal code would have at least said, even if you're going to do it from the point of view of the reader, it should be, did he communicate something that he was aware was a threat, or that he was aware would be taken as a threat?
Just for clarification for my part, when the instruction was given to the jury of reasonable person, are they assuming reasonable person is a person who didn't know the context between the relationship between all these parties involved and like the events leading up to the past, just somebody who took it at face value?
Well, since it's from the point of view of the recipient, then the jury would be asked, if you, certainly you take into account all the contextual circumstances.
Okay.
If you were whomever the prosecution said was the person or persons being threatened, right? In one case it was his ex-wife, right? And in another case it was the kindergarten class, which was a little bit amorphous because it wasn't a specific class, right? And then the police were being threatened. So in each of those, the relationship and the context are different, but you would say, would a reasonable person seeing this regard it as a genuine or true threat? Okay? Yeah. Go here and then there.
What was your question, that negligence?
I
was
said,
answered?
what model penal code standard does this inherently reflect?
Is negligence.
And it's negligence. So if we just said the model penal code default rule is recklessness, so the trial court at least said, you know what? We're going to, as a matter of interpreting this federal statute, which isn't bound by the model penal code, we're going to interpret it as having a negligence standard. Okay?
For the code that was used, it said it based a crime to transmit in interstate commerce. Is that because it was on the internet, or because, like, the kindergarten class was in general and the police officers?
That means because it was on the internet. Why do you think the statute says it had to be transmitted in interstate commerce?
Because it has a private
No.
Federal.
And
It wouldn't have standing in a federal court. It would be like a similar, be a state offense.
not, well, you're on the right track.
They wouldn't have jurisdiction over it?
Who would?
The federal wouldn't have jurisdiction.
The federal what?
Government.
Federal court.
Why?
Because if it was just in one state, it wouldn't be interstate and it can only regulate.
But why, this is the language in the statute, so we're talking about what Congress wrote. Why did Congress write it that way? Anyone? This is sort of your first preview of con law. Maybe a second.
To preserve states' rights?
Well, yes, that's the underlying reason. Congress only has power to regulate interstate commerce under the Commerce Clause. So if Congress tried to regulate purely I-N-T-R-A, intrastate activities, then it would be unconstitutional under a couple of Supreme Court cases that we'll read in con law, you'll read next year in con law 1. Okay? So Congress has to put in this sort of requirement that the behavior being regulated either affects or involves or is part of interstate commerce. And then Congress's power is triggered, and the federal courts can then apply the statute. And if it's a disputed issue, then the defendant will try to argue, hey, there's no hook to my conduct being interstate. The statute may require it, but they can't show it. And you can get some cases on that. So it's a matter of congressional power in order to preserve the idea that there's a realm for the states into which Congress cannot intrude.
So in this case, Facebook would meet the condition of interstate commerce
Facebook is about as interstate as you can get.
because it spreads to like pretty much every single jurisdiction.
Yeah, I mean, his Facebook posts were not limited to Pennsylvania. Right? You could see them if you wanted to. They're probably not still up, but at the time you could have seen them if you wanted to.
So this is just like a question about like jurisdiction. So he was posting this on like community bulletin board.
The prosecution, if they wanted to invoke 1875, would have to make some showing that that posting on a community bulletin board, let's say at the local grocery store has like a posting community board, and he posted them there. They would have to somehow show that that either went interstate, good luck, or that it affected interstate commerce. You know, maybe, you know, I can imagine facts in which you could try to show that. Maybe because of the controversy over this, the Kroger decided to take out all their community bulletin boards because it was causing such a fuss and driving away customers who feared for their lives while shopping at Kroger. That would have an effect on interstate commerce. So you know, whatever. So, but just by itself, that would be a good counterexample if I didn't have all those other facts, where just posting it on a very local community bulletin board might not be interstate, and it would be purely a state matter. Okay? All right. So that's what the trial court does, and the Third Circuit Court of Appeals, which governs as the intermediate appellate court, affirms. It says the only intent necessary was to make the communication, not an intent to make a threat. As long as, regardless of the person's intent to make a threat, if a reasonable person would have seen it as a threat, he can be convicted. Okay? So, what does Chief Justice Roberts say about the statute?
He says that the fact that the statute doesn't have a specified mental state doesn't mean it shouldn't.
Well, that's how that's the reading in part. But the statute itself, does it impose a mens rea? Does it include one?
No.
And the court rejects. The court says, look, the statute does not specify that he has to have any mental state with respect to these elements. And he says the word threat, Alonis tries to argue that the word threat necessarily includes an element of intent to threaten. And he says that's not true, right? Because a threat can also be from the recipient's end. Right? If I feel threatened, that could constitute a threat under an ordinary dictionary definition. So that doesn't, the word threat by itself doesn't get us anywhere. So what does the court do? Does the court say, okay, no mens rea, now we have to decide what I told you was a constitutional issue about whether convicting somebody who didn't intend to threaten violates their First Amendment rights. What does the court do?
The court says that the reasonable person, thinking it was a threat, shouldn't stand in this, because for criminal law, you need to have awareness of some wrongdoing for them to be convicted. So.
And we've talked about these approaches, the really terrible Kentucky approach. We've talked about the model penal code approach of using recklessness as the default. What approach does Chief Justice Roberts here use to decide what mens rea should be read into the statute if one's going to be read in?
He's saying that if the defendant transmits communication for the purpose of issuing a threat or with knowledge that the communication will be viewed as a threat, then he can be convicted with a mens rea. But in this case, Alonis said that he was not intending to, he didn't realize this would be viewed as a threat.
Hit me with that again?
He said that if he would fulfill the mental state requirement required by the section if he had a purpose of issuing a threat.
That's not what the court does. That's not what the court does. What does the court do?
They say that the only mens rea that can be read into federal statutes is whichever one is necessary to separate the wrongful conduct from otherwise innocent.
Good. Exactly. Right? So here's another approach to how you go about deciding which mens rea to insert when the statute is silent. The court says what you need is, making a statement. What the prosecution wants to say is that he only had to have intended to communicate, right? That he certainly intentionally communicated these statements. But the court said that could be entirely innocent. That doesn't separate what's entirely innocent in terms of communications from what is wrongful, right? So we do need some kind of mens rea that goes to that key issue of separating out. This is on 255, separating out that the mens rea, or separate wrongful conduct from otherwise innocent conduct, right? He has to, in some way have a mens rea with respect to the nature of the communication. And what does the court say it can't be? What does the court rule out?
They rule out recklessness.
They rule out recklessness? What does it say on 256 about recklessness?
256. Always stated that the finding of recklessness would not be sufficient. So
That's not what they say.
Okay.
Do they rule out negligence?
They rule out negligence. What do they say about recklessness? Cannon?
Yeah, they say that the government hasn't argued that yet, so they're not going to address it. Right?
We're going to remand,
Yeah.
right? Since the court frequently will say, look, if the case is going to have to be sent back to the lower courts, if there's a point that the parties have not argued, have not briefed, it's not right for the court to decide it. So the court on recklessness says, well, recklessness might suffice. The parties disagree on that at oral argument, but they didn't brief it. So we're going to send that question back. Now, as to ruling out negligence, what did the court say?
They said that the reasonable person standard is familiar with civil liability for law that's inconsistent with the criminal conduct of awareness of wrongdoing.
Awareness of wrongdoing. Because remember, recklessness does include awareness of wrongdoing. So the court starts to open the door to that without deciding it. But since negligence is only, well, you should have known. That's great for torts. That's great for civil liability. But we're not going to use it as a default to read in when the legislature is silent. Okay? So the court rules out negligence, and it said if the legislature wants to have negligence, if Congress wants to have negligence, they can certainly use it, but it has to impose it. It has to say so explicitly. We're not going to use it as a default. So, what do you think happened on remand? I beg your pardon? Different instructions, that's one guess. Anyone else? I beg your pardon? They went with recklessness, but there had to be a trial, right? Because the jury had never been instructed as to whether his conduct was that they needed to find whether his conduct was reckless.
So they held him to the standard that a reasonable person would think that this would be like
That's negligence.
No, like a reasonable person would perceive this as a threat.
From the point of view of the communicator.
Yes.
Okay, that he knew the risk that it would be perceived as a threat.
He should have known.
Should have known? No, the court rules out negligence. Should have. If you use should have known, you've gone down the wrong road.
Should have known is negligence, right?
Right.
A reasonable person would be should have known, and then a reasonable person, the threater did know the risk.
Knew the risk. Didn't necessarily intend that it be taken as a threat, but knew the risk it would be and took it anyway. Was aware of the risk. That would be recklessness.
So you could say that because his wife had previously gone to get a protective order, even that these type of statements were threatening, so that could possibly be reckless.
And what therefore would have happened on remand, do you think?
They could have proved that past posts were received as threats.
And
The other ones could be
But-
seen as
so the prosecution would win after new trial.
good. Right.
There was no new trial.
What?
Here's what happened. You're all got the law basically right. But a lot of times what happens is courts, when they get reversed, like the Court of Appeals here got reversed by the Supreme Court, they're not happy They like, they dig in their heels, they get stubborn. And what the Court of Appeals did was use a rule called the harmless error rule. Have you talked at all in your other classes about harmless error yet? No. This is brand new? Oh, good.
Oh, great.
The Court of Appeals said the harmless error rule is, okay, that let's say the trial court here made a mistake, right? It imposed the wrong mens rea. It did not hold, it did not tell the jury that it had to find either that he intended to issue a threat or that he was at least reckless as to whether or not it would be taken as a threat. Okay? So what the Court of Appeals said is, under the harmless error rule, could any rational jury have reached any other conclusion than to convict him under the right standard? If it couldn't have, then the conviction stands without the need for a new trial. And here, it seems to me, that is a big stretch to use the harmless error rule, because under that rule, it has to be really, really clear. No rational jury could possibly have found anything other than that he had knowledge, even though no jury had ever been asked that question. Now, the legal standard the Court of Appeals applied was not recklessness even. It applied an intent standard. Not that he intended to threaten, but that he intended to do something that a reasonable person would perceive as a threat. Right? That in other words, he intended, that's where we get our mens rea, to communicate what a reasonable person would perceive as a threat. Okay? So that was his intention. He may have thought from his own point of view, well, I don't really mean to threaten, but I mean to do something that a reasonable person would see that way, whatever my subjective viewpoint was. And the Court of Appeals said no rational jury could find anything other than that he intended to communicate something that a reasonable person would perceive as a threat, and that makes him culpable. And the Supreme Court, he and Alonis then sought review again, said, wait a minute, I'm entitled to a trial on this. I'm entitled to have a jury decide that question, even if that's the right standard. And the Supreme Court denied review. We're done with you. We've set the standard, we've made the rule of law, we'll allow it to be applied in future cases. Questions? Okay? So, as your first introduction to harmless error, it is a way to, when used properly, it's a way to avoid unnecessary retrials, to conserve judicial resources. I'm not sure it was used properly in Alonis. Okay? So we'll stop there. We're a little behind because we didn't get to Gray today, but we'll try to catch up in the next